Okay, thank you very much for talking to us, Deb.
No worries.
I wonder if you could please tell us a little bit about your background, your research interests.
Well, my main research focus has been on the representation of football and sexual assault in the Australian media. So looking at the way that language is used particularly to distribute blame and responsibility, and which is mostly what I found, was that it was projected onto the women involved, and so there are a number of stereotypes that were constructed of female complainants as excuses for or reasons why women would lie about sexual assault.
And so what media are you looking at for these things?
Well, I initially started out with print news and TV, but I've recently been moving into social media as well.
Great. And you're giving us a guest lecture in a week's time, actually, at the
Yes.
Jewish Holocaust Centre, and we look forward to that. What I want to do here is not to give away too much of that. I want to do a bit of a teaser, Matrix style, what is the Matrix, and see if it's as successful as that. So I'm just wondering if I can ask you a few questions to warm us up to this issue and for me to put in the meLecture for this particular topic. In terms of the overall issue of new or digital media and the law, who are the key stakeholders we need to be thinking about for these issues?
Well, you've got the legal practitioners, so the lawyers and judges, but more increasingly it's also the accused perpetrators and the victims or complainants in crimes who have a large stake in these kinds of issues because they're often the ones who are using social media.
And another key stakeholder for us is obviously juries and the issue of trial by social media. Now, in the lecture, you'll be talking about sexting and trial by social media, but the great thing about your background and expertise is that you've actually been on a jury.
Yes.
And the reason why I wanted to have a quick chat to you now is that I have a lot of students, international students included from all different kinds of countries who might not have a similar or a drastically different legal system, but I imagine that there are some Australian students who also might not be incredibly familiar with how juries work. And so can you tell us when it was you were on a jury and a little bit about that?
It was 2006 or 2007, and so you get called up, you go into the, whatever it is, not the court, but you go into the place, and then people pull out names or numbers from a ballot. So then you go into a courtroom and then 12 names are pulled. It's all at random. And so to get on it, so if your name is pulled or your number is pulled, then you walk past the accused in the courtroom and they are told your age and occupation, and that's it. And as you walk past them, then they can veto you if they think that for whatever reason that they don't want you on the jury. And so then once 12 people have been passed, then then they go into the trial and it begins.
And can I just ask, with the vetoing, this is done by lawyers from either side?
It can be the defendant. It's often the defendant themselves who will say, not that one.
And what kind of information do they do this by?
Just your name and occupation.
Yeah.
It's very different from the American system. If you've seen Law and Order or any of those shows where they have the jury selection and they get to quiz the jury, it's nothing like that here. It's just, Susan Jones, 24, teacher. That's it. So not even Susan Jones, sorry, it's just 24 teacher, juror number 20.
And when they say teacher, probably out.
Yep. It only happened a few times, but every single teacher who went past was vetoed. And I was in courtrooms for 2 days before I got on a jury.
Right, interesting. And you're not obviously allowed to talk about the specifics of the case, but if you could tell us what kind of case it involved, perhaps, and what the process was from within the jury.
Well, it was a real eye-opener, and I actually spent I was actually involved in the case for 4 days, and I spent the whole time walking around going, this is so not like TV, this is so not like TV. Once you're in the jury room, so in terms of deliberations, you're given very little. I mean, the case that I was on was a minor case of violence. But it did take 4 days for all of the evidence to be presented. So this is 4 days of kind of 10 in the morning to 4 in the afternoon. And once you get into the jury room to deliberate, we were given a bag of clothing and a recording of the defendant's police interview, and that was it. As in terms of what we were given to help us decide, it was just going on the notes that we'd taken and what we'd heard in the courtroom. And so and there was no structure. We were just told, go into a room and figure out the facts. And I was the one who decided that there was going to be a process. Somebody in the room wanted to just stick our hands up and say, yep, reckon guilty.
Right at the start.
Yep. First thing when we walked out after 4 days, and this person goes, right, we reckon she's guilty. And just wanted to do a hands up vote then. And I said, hey, how about we figure out what the charge is that we're supposed to be deciding on? How about we figure out what the law is and make sure that we've all understood that, and then figure out whether the evidence leads us to that kind of conviction. If it leads us to a conviction or not, leads us to that conclusion. And that was what happened, because I was the vocal one and everyone else or the most vocal one, and everyone else just went along with that.
Not going along with you, but going along with your intention or desire to have a due process.
Yeah, I didn't actually express an opinion at that point, one way or the other. I just said, okay, what was the law? And it turned out that we didn't actually have a clear understanding amongst the 12 of us what the law actually meant, and we had to get clarification of what it was. And so I don't think I actually expressed an opinion of whether I thought the defendant was guilty or not until the very end, because I really wanted to figure it out based on the evidence that we had, and to make sure that we weren't making the wrong decision.
And so to summarise this kind of scenario, there's several problems in this kind of situation, I suppose we could say. You've got a lot of people who are is compelled too strong a word, or that it's people who are not voluntarily there in the strictest sense.
Yeah, no, they're not voluntarily there. I mean, the people they weren't upset about being there. I mean, nobody was spending the whole time going, oh, I've got better things to be doing this or anything. But they were just there because they had to be. And nobody was particularly taking copious notes or anything like that. It wasn't, like they were studying for an exam. I saw people who wrote one sentence from the whole 4 days, and they just weren't that engaged or that interested. It wasn't a desperately interesting case, I suppose you could say, and I found it fascinating because I find the law fascinating. But they were all more interested in playing in the jury room in breaks in between.
I'm starting to get really worried.
And stuff.
I'm getting board games. That kind of makes it interesting to me, but I'm starting to get really worried about if I'm ever allegedly done something.
This wasn't during deliberations, because you're not actually allowed to talk about the case until all of the evidence has been presented. But that didn't stop people from doing that either. I mean, the very first break, I overheard people saying, a couple of people saying, oh, well, people from that area, they're just like that.
Right. Yeah, so you've got prejudice coming in. And
so
you've got issues of attendance kind of being not 100% voluntary. You've got engagement issues. You've got understanding issues. You've got people who don't understand the law necessarily and what they're being asked to do and needing extra advice, even if that's comprehensive.
They're complex things. I mean, law is never simple. And it's also just retention, remembering what's being said. People don't generally have particularly advanced note-taking skills. I mean, even people who go to uni aren't necessarily really good at getting notes down for everything that somebody said in a 1-hour lecture, let alone 4 days.
People write down everything I say in classes.
Oh, of course they do.
Yeah.
Yes. But it's very difficult to kind of keep all of that in your head, and so people tend to sort of go with, well, I believed him, and he was saying that something happened, but it was it was a vague kind of memory. And
is this a little bit like the castle? It was the vibe.
Well, I can't say I was terribly impressed with the performance of the defence barrister. Yeah. I do remember saying afterwards that I could have done a better job of defending the person.
Yeah.
There was at one point when the defence barrister put forward an alternative scenario to the one that the prosecution was saying. It was actually so ridiculous that I burst out laughing in the jury room. And so the judge sent the jury out, obviously yelled at the lawyer. When she called us back in, then he was made to apologise to us for saying something so stupid.
Well, I guess to summarise what I've been doing and to be completely transparent about my line of questioning, because you kind of feel like you might be, in the witness box at the moment in a sense. The reason why I'm asking you about all of these issues, if not problems, if I can call them that, of attendance, of engagement, of understanding, of distractions, of, the conventions of you're not supposed to talk about this, but it gets done anyway.
Yeah.
All of these things you experienced and are no doubt representative of a great deal of many cases, and this was not necessarily the most significant kind of heinous crime involved, and obviously it becomes more important, perhaps you could argue, with other cases. What happens, this is 2003, 2004 you mentioned.
2007.
Sorry, 2006, 2007. What happens when you bring social media into all of this? You've already got this kind of quite fraught process. And you didn't have Facebook at its peak at that kind of time.
It means that if it's a high-profile case, I mean, the case that I was on would not have made a local paper for anything. It wasn't that big a deal. But if you've got a big high-profile case, avoiding any kind of mention of it, you'd have to stay away from Facebook. I mean, everybody says, if you miss a episode of Game of Thrones, you have to stay off Facebook until you've seen it. It'd be exactly the same, if not worse, with a high-profile case. And getting people to stay away from Facebook is kind of like asking them not to eat chocolate for 3 months. It's a really hard call. So it would be very difficult, much more difficult these days, to avoid the issue of juror contamination from hearing media reports on the case that you were sitting on.
And so the issue is that you do have your mobile phone taken off you.
Oh yes, and they insist that you turn it off, and it goes in a box and it's taken away
until
the end of the day,
which you get it back and then come back the next morning and give your phone back. Yeah, so it's an interesting kind of, you're not in solitary confinement as a juror.
No.
Yeah.
Not unless, I know sometimes on really big cases, then they do sequester a jury if they think that there's absolutely no way that they could avoid discussing the case or hearing things about it. Like if it's been really controversial, then sometimes they'll put them up in a hotel room.
Yeah, that's interesting. So now with social media, ubiquitous digital media that we have in our lives, is there no way that you might hear about something?
Well, I mean, to use the Game of Thrones analogy again, I have actually managed not to have any serious spoilers, and I haven't seen any of season 4. So it is possible. But you have to be really, really invested in not finding out anything. And I think that it would be a real temptation. I mean, because, like, as a juror, and there've been a number of cases of jurors who have gone out and investigated cases on their own because they were, interested in it, or they just thought that something was a bit wrong with what was going on. They wanted to know more about it, which is completely illegal, by the way. But you can see it would be more of a temptation to just sort of, you catch in the corner of your newsfeed, something catches your eye with the name of the defendant, and it'd be hard to make yourself not look, because it's not that you're not looking because you don't want a Game of Thrones spoiler, it's because you're not looking because you're not supposed to, but you really kind of want to know.
Yeah. Well, that's fascinating stuff. Well, thank you very much. I'd say that's a pretty good teaser, if not a trailer. The long Willy Wonka-style trailer of 10 minutes of 20 years ago they used to make. But I think this will give everyone a really good insight into the jury system, and we look forward to seeing you at the field trip very soon.
Yep, I'll see you then.
Thank you for watching, and I look forward to seeing many of you at the field trip next weekend. Tiffany thinks you should go. Don't you, Tiff? You want to get down? Whatever.